Certain means informasi yang betul lah. I mean like 100% correct. There's no human error, there's no misrepresentation, there's no fraud, there's no forgery and all. Okay, so if you want to know the details of those element, forgery, fraud and all, semua ada dalam buku, baca sendiri. Okay, next. So, what is meant by free consent? As according to law, the law requires that party enter into contracts with their full and free consent. That means it is 100% with your own on consent lah. You allow yourself and the other party, okay, to enter into a valid agreement. That means you agree with the terms, and of course you fully understand the terms and the clauses in the contract. This is not law sangat. Okay, the contract is rescind for lack of consent. Okay, that means it is sack off, okay, or cancel. The burden of proving lack of consent normally lies on the person seeking to rescind the contract. Okay, meaning if let's say one of the parties in the agreement, let's say you are doing bilateral kind of contract, because again contract has two ways of doing it. First, unilateral, which is one to many. Okay, that means one to large people at large. And number two would be bilateral, which is one to one. Okay, so one of the party, if let's say you feel disagree about the terms, and you find out that there is a force being done to you. Okay, so that you want to rescind the contract, so therefore you need to find the evidence of the proof. Okay, this is what it's talking about. Section 10 of Contract Act 1950 provides that all agreements are contract if they are made by free consent party. This is the first part. That means under Section 10, if you are about to answer this kind of question, you have to make sure you put Section 10 of Contract Act as the proof under the statute that what is agreement all about. Okay, so agreement is this one. First of all, it must be free consent. It must include free consent from all the parties. Okay, Section 14, 14 of Contract Act, consent is said to be free when it is not caused by one or more of the following: coercion, under influence, fraud, misrepresentation, mistake. Result in the voidability of the contract. Okay, let's see what is lack of consent. So the result will be two. One is voidable, another one is void. Okay. So for voidability, voidable contract is defined as in Section 2, subsection I of Contract Act, because subsection 2 gives all the interpretations of Contract Act and whatever you find in Contract Act. Okay, so Contract Act as an agreement which is enforceable by law at the option of one or more parties, but not at the option of others. That means it will strictly depending on the injured party normally. So what is meant by injured party? The one that being affected by the party, or the one that feel unfair with the arrangement of the contract. So therefore, this party may have an option to rescind the contract. So if you are about to choose that you want to void the contract, then you can raise the evidence of, or burden of proof is under you. You have to prove that there is misrepresentation. Then later on, you can the both parties can decide whether to void or to just orang kata moving forward with the contracted agreement. Okay, and number two is the void. Okay, void, Section 2 subsection G of Contract Act 1950 define void contract as an agreement which is not enforceable by law. It gives rise to no rights obligation. That means it is one of the example is going to be void ab initio, Section 10 of Contract Act 1950, which is use contracted with the parties whom are number one, minor, which is under 18. Number two, which is intoxication, under it's not sober, mabuk. Okay, and number three would be those who are insane, or those who are not in the condition of sound mind. So those people will have no consideration at that point. They want to contracted into any kind of dealing. Okay, so it's unfair if let's say you ask them to you ask the kid of 5 years old to be in a contract with you of purchasing land of 2 million ringgit. Okay, next. So let's go for question.
Yes.
Alhamdulillah. Okay, coercion and duress are the same thing. Okay, but English law is not extensive to duress. Okay, why? Because English law does not recognize duress of goods. Okay, meaning in English, duress is you restrain them from getting something lah. Okay, like I did example with the degree class before, that someone put a gun on you. Itu force lah, considered as force, but duress. But you have an option whether to stop the action or you just let it be. Okay, yelah kalau dah ada pistol atas kepala kan, orang semua takut nak mati, baik aku ambil rumah daripada aku mati, betul tak? Kalau aku buat macam tu. Okay, the effect of coercion is that the agreement in contract is voidable because you still have option. Okay, let's say people force you and detain you, okay, in order to ensure you give your signature or your sign to agree for the purchase of um, RM2 of karipap. Okay, so it's something like that lah, duress. But logically, you will okay lah kan, takkan kau nak mati because of karipap, right? But then, because it is under law, so you still have option to agree or not to agree. But if you agree, you will die. But if you not agree, if you not agree, then you will die lah, kena tembak. But if you agree, you will get something out of it. So still, you still get something. But then, the only bad moment is that the performance of the contract itself, because you need to be forced to sign the contract, so which is bad. But at the end of the day, you get something. Even though it's like weird what it said, coercion normally forbidden by penal code. Normally penal code is akta pula kanun kesesaan. Colik, mencolik lah, you detain orang, you colik is one of the example, okay, yang membuatkan dia adalah voidable. Voidable bukan void. Remember, you have to differentiate voidable and void. Void daripada awal dah formation dah tak boleh. Tapi voidable ni, you ada option, sama ada you nak teruskan kontrak ataupun you tak nak teruskan kontrak, you want to cancel it, up to you. You have the call. Okay, section 16 section 1 highlight about the influence by one or dominant position to obtain unfair advantage. Okay, like my example just now, I'm talking about I myself as a lecturer. I can say that, hey, if you don't pay for my lunch today, I will give you C minus for your exam. Okay, that means, contoh lah, I kena under influence, patut orang lain yang ngadukan untuk I, tak boleh. Under influence dah discuss dengan you, meaning someone who has higher power than you. Like in the organization, let's say you are the director, okay, because you are the director and the other party is the staff, the normal staff. So you said apa? You have to follow my rule because I'm the director of the company. So that if I say A, you say A. Okay, so it is something like influence. Okay. Section 16, section 2. A party deemed to be in a position to dominate the will of another, where one party, the will of another, it means that the consent, improvise pula, affected the consent. A holds the real or apparent authority over the other. That means in the company lah, the hierarchy of the company, sending fiduciary relation over the other. That means fiduciary duty. Fiduciary is not financial. We have monetary and fiduciary. Fiduciary is something like blood related, or something that the power of like say the uncle, you are the uncle, okay, your uncle force you to sign something, okay, your father-in-law or your father, your mother, that one is the fiduciary relation. Make a contract with a person whose mental capacity, macam gila. Contoh dia macam those yang memang nampak normal tapi sebenarnya dia tengah dia syndrome. Tak boleh, syndrome nampak muka dia. Those yang memang ada depression and you knew the condition of that person, but then you use that weakness, okay, to ensure the party enter into an agreement, a transfer of land to you yourself. Okay, so this is example of position that indicates the dominance of the person. Okay, in the case of Encik Noria, a Malay woman who was of great age, this is like one of the cases I baru baca recently, executed a contract in which she agreed to transfer her property in form of land as a gift to her nephew. Okay. the court found that she was feeble old woman, unable to leave the house, relying entirely upon the correspondent for everything, even for her food and clothes, and leaving the management affairs to him. She had no knowledge of her own affairs or to the value of her property. This is currently happened to apa ni, one of my ni lah. Dispute arose between the parties and the appellant wished to set aside the contract. Okay, the court set aside the gift made to him on the basis of undue influence. The respondent was deemed in a position to dominate the will of the appellant, whose mental capacity was permanently affected by reason of age and bodily distress. That means nanti you dah besar, kalau ada mak ayah kan, okay, mak ayah yang educated, okay lah. But then kalau yang sejenis yang kat sekolah, tak tahu membaca, you kat situ, anyone can influence ataupun anyone can ambil kesempatan, take advantage over them. So this is the one that we don't want to happen. And if let's say this case happen, this is section 16 subsection 2 and section 16 of Contract Act will speak, okay, the option of the party lah, of the affected party, which is in this case would be the encik tadi tu, okay, the perempuan tadi But remember, the third party tak boleh report for her, okay, she herself need to report lah, macam dia akan cakap sendiri that I want to raise a case that I've been falsely signed the agreement because of my incapability. Okay, section 20 provides that when consent to an agreement is caused by under influence, the agreement in a contract voidable. It's a contract voidable at the option of the party whose consent was so caused. Okay, that means the party only, maknanya orang yang kena paksa tu anak dia ke siapa tak boleh. Okay, next. Tapi kalau dia dah meninggal, boleh lah. Okay, you boleh brought the case. But then still, the burden of proof is important. Section 17, certain acts which are committed with intent to induce another party to enter into a contract. This is fraud. That means you give wrong story, wrong information. This is totally wrong, and you are intentionally give the wrong kind of info in order to fraudulently attracted the party to be in the contract or force the party into the contract, because the party has the capability to think and still not old and have has a great mind to think. So you think other way in order to ensure you can influence him. Okay, then the other way is fraudulent lah. This fraud act lah. In other words, act done with the intention to deceive. Okay, deceiving kind of action. Fraud includes any of the following acts. The first one, the suggestion as to a fact of that which is not true by one who does not believe it to be true. Okay, the action concealment of the fact by one having knowledge or belief of the fact. Let's say if you are selling something and you want to deceive the person. Okay, so you said, oh, this iPhone can transform to become transformer, or the car, or the lorry. Okay, so bodoh juga lah sampai percaya tu kan. But still, it is still fraud lah. Okay, or a promise made without any intention of performing it. Macam contoh, this one you all selalu buat. Macam mak cakap, pergi basuh pinggan. Kejap mak fraud lah tu. Tapi sebenarnya you tak ada niat nak basuh pinggan, betul tak? Percaya dia orang semua buat. Korang semua buat kan? Once lah at least in your lifetime. Tipu tak buat. Any other act fitted to deceive, and any such act or omission as the law especially declares to be fraudulent. Okay, next. The effect of fraud is that the agreement in the contract is voidable. Voidable because section 19 said, provide that when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement in the contract voidable at the option of the party whose consent was so caused. Okay, but to determine this is quite difficult. To give the proof of evidence, to provide evidence to the authority is quite difficult, because normally the concealment tu sometimes the thing is already done. People dah mati dah. Barulah kau realise that, itu fraud lah, mana ada kiamat esok. Macam tu, something like that. Kiamat, okay, maaf. Mere silence, assignment. Mere silence as a fact likely to affect the willingness of a person to enter into a contract is not fraud. unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silent to speak, or unless his silence is in itself equivalent to speech. You think that because that lady ada spare tire, so it's okay lah, tak apa kan. But then you just diam je. That is silence, right? Okay, so bukan fraud lah. Okay, but kalau let's say, kalau you dah tahu tapi you sengaja because you punya dirty mindset, oh bagus juga ni, biarkan je tayar tu rosak, nanti kan kalau meletup tayar tu, dia mati. Tak boleh juga macam tu. Dia macam kalau tayar tu rosak, then dia akan minta kita ganti. Oh, nanti kau boleh cakap tayar tu is not, the tire is not under the warranty. Then itu lain. Okay, that one is totally fraud yang kau ajar. Okay, tak adalah. I mean like that one is totally misrepresentation. All the elements lah. We will see lah that one. As accordingly, court will see. Okay, under Weber against Brown, the respondent sued the appellant for damages in respect of all alleged false and fraudulent misrepresentation relating to the number of rubber trees on the estate. Okay, these cases you have to read first. Dia punya fact of the case. This is just a case brief, and then it was held that the appellant's statement that he counted the trees taken in conjunction with the written enumerated of trees amounted to fraud. Dekat, nasib baiklah kau tak kira berapa rambut. Okay, kalau kau nak kira rambut, rambut awak ada 2 juta. Macam tu. Fraud tak? Okay, the court also agreed that the representation made by the defendant had clearly induced the plaintiff, to exercise the right to purchase. Okay, macam dia kata macam ni lah. Before the respondent wanted to buy the plaintiff wanted to buy the land, and then he asked the respondent how many trees are there, okay, in the land. I think the big kind of, the old kind of trees around 250, and then the small one 240, and then the cendawan and all adalah dalam 500. That is totally a fraudulent statement, right? Fraudulent misrepresentation. Normally Malay and Malaysian like to do this. Macam, how much to put in your, when you cook something, right? How much to put garam? Oh, agak-agak lah. The word agak-agak tu sometimes is fraudulent. Okay? Because, yelah, mana tahu agak-agak, my agak-agak is satu genggam gula. Or satu bekas besar tu. But then your agak-agak is actually secubit. Secubit garam tahulah kan. Tapi kalau dia kata agak-agak pun, how many cubit? Macam tu, something like that. So, when it comes to law and contract, it is very important for the information to be certain. Okay, you cannot put agak-agak, secubit, segenggam, sedepa, sehasta benda semua tu. Itu all kind of contract. Okay, but now since we have our measurement system developing, so we can't accept that kind of measurement. Okay, then number 4, misrepresentation. A misrepresentation is a false statement of existing of past fact made by one party because of a time of making a contract addressed to the other party to the contract, and the maker of the statement believe that what he said is true. Okay guys, so the next number 4 and 5, okay, misrepresentation. So misrepresentation is a false statement. That means the statement is untrue, and if you are talking about the information, the fact, other people will say, no lah, but you yourself is living in delusion, saying that, yes lah, I believe that. That means, oi, apa tu? Aku punya seluar pendek naik. Okay. Okay, but you are not the one that to be blamed for, okay? Because you yourself believe that when you make a statement saying that, let's say the car has 6 tires, so you believe that because you saw that, okay? But you are actually in delusion, okay? So it is misrepresentation, okay? Section 18, misrepresentation includes a person makes positive assertion. That means it's positive. When you say tire ada 6, a car has 6 tires, it will be great lah kan, extra tire. But it is not true, okay? But you believe that it is true. Any breach, section B, any breach of duty which is made without intention to deceive, okay? You breach, you cakap something tapi tak ada niat pun nak buat benda jahat tu. Okay, causing, however, innocently, a party to agreement to make a mistake as to a substance, substances, means because of your statement, the other party wrongfully do something, okay, and then which is subject to the agreement lah, tapi due to your statement, I didn't pay for certain amount, because I believe that your statement is true, okay, and then later on it turns out to be that your statement is misrepresented, so it's not my fault, but it is your statement and it is you yourself. Kenapa kau hidup macam tu? Okay, Syed Ahmad Asagov, bagus family dia ni. Okay, the basic difference between sekejap nak naik sikit. Biasalah saya curi. Okay, the basic difference between representation and fraud is that in fraud, the person making the representation does not himself believe it's true. Okay, fraud ni tipu lah. Kau pun tahu tayar tak ada 6. Tapi kau saja nak tipu untuk tambahkan kau punya sale. You say that, tayar ada 6. Tapi sebenarnya tayar memang ada 4 pun. Logically lah. Cuma dalam cerita Mr. Bean, tayar ada 3. Okay, but yang 3 tayar ni can be misrepresentation. Because you saw that, okay, in Mr. Bean's movie. But then, you believe it, okay, you believe it to be true, so that's why you tell anyone else that yes, there is 3, okay, so it is considered as misrepresentation, okay, it is not fraud, okay, but fraud, when you say tayar ada 1, orang lain pun cakap you bodoh, you pun rasa diri you bodoh kalau you percaya benda tu, betul tak? Tapi ada percaya. Okay, he may believe that representation is ni lah macam ni lah, this is the one, representation believe what he said is true, and then fraud knows that he said is lie. Kau tanya soalan macam ni, best juga masa exam. Section 19, Section 1 provides that when consent to an agreement is caused by coercion, fraud, or misrepresentation, these 3, the agreement in a contract voidable at the option of the party or injured party whose consent was so caused. Okay, maksud whose consent was so caused is the one that giving the consent and the one who fall into the group of injured party. Okay, bukanlah injured kau pergi main game patah kaki sebab tu bukan injured. Injured means tercedera, tercelaka. Not tercelaka, but tercedera. Not tercedera lah, ter-affected lah. Okay, in bicep. Tak tahu nak jelas benda macam ni. Wilkinson lah. The respondent agreed to buy from the appellant certain land for sheep farming. The respondent relied on the appellant's statement that he estimated the land would carry 2,000 sheep. Okay, estimation. The appellant had not, and no person had carried 1 sheep farming on the land in question. Okay, the land in fact could carry less than the said amount. The respondent alleged misrepresentation. The court held that the statement was merely an honest opinion by the appellant and the sale cannot be set aside for misrepresentation. That means you yourself believe that it would actually, 1 bus or 1 van ada 11 chairs, but you have seen people bring about 15 inside the van. But then you believe so, right? And then suddenly, because of the act of you to represent that the van can carry about 15 as per your opinion, and you believe that, and you tell your customer so, and then after that customer accident bawa 15 orang. So sebenarnya van tu boleh bawa 11 orang je. So it is not your fault. I'm honestly and stupidly think that the van can carry 15. But I've forgotten that the fact is that yang bawa tu semua baby. So baby kecil kan. So the party pula 15 tu semua size XSL. So it is something that stupid over stupid. Okay, next. Abaikan Okay, kita betul sekejap. Then mistake. Okay. So Section 21 of the Contract Act provides when both parties to an agreement are under a mistake as to matter of fact essential to the agreement. Let's say for the color, a matter of fact essential. Essential means fundamental. Okay, element of mistake. I think this one is void. Okay, fundamental element of the subject matter. I did tell you that the consideration will strictly depending on the subject matter. So subject matter will be the fundamental elements of the contract. Okay, so it is an essential or vital element of the contract. So the agreement is void. Okay, it is equivalent to the one that we discussed before under section 10, which is comprises of the party who can be in the contract. It is supposed to be the major age and then majority age, and then not intoxication, and of course there's no insanity. Okay, available. Okay, elements of mistake. It must be mistake of both parties. Means that both parties are not stupid but mistakenly agreed for something that is not true. Okay, there must be a mistake as to matter of fact essential to the agreement. So it should affect the fundamental of the contract, fundamental breach, okay, of the contract. That is what I think I put as one of the reason for my unfair dismissal before. Fundamental elements of the contract, which is the ada ni lah the terms, okay. A agrees to buy B, a certain cow. It turns out that the cow was dead at the time of the transaction. Though neither party was aware of the fact the agreement is void. Kau nak beli kereta tapi kereta kau meletup sebelum hari kau jual, so kontrak tak ada So the next day, if you are unaware, rumah kau terbakar, kereta kau terbakar semalam, tapi hari ni kau still lagi tentangkan agreement, so agreement kau tu void. Itu je masalah dia. Masalah dia pula, dia punya discussion. Okay, example dia Galloway. Galloway is famous case. A separation deed between a man and a woman was declared a nullity because it was made on a mistaken assumption that they were in fact married to each other. Bodohnya. Sebenarnya diorang tak kahwin, kan? Okay, kau tak kahwin, tapi kau pilih kahwin. Lepas tu kau tiba-tiba nak ask for separation because kau gila harta. Tiba-tiba, tak ada separation sebab kau tak kahwin pun. That's the example.